How long can you leave a child unattended in Illinois? Children today are rarely left alone. Parents are always concerned about safety, and society often questions whether kids can handle being unsupervised. But life happens. Parents might need to run an errand or step outside briefly. Understanding Illinois law on leaving children alone is essential to avoid legal trouble. Is leaving a child unattended a crime in Illinois? Illinois law defines child abandonment under 720 ILCS 5/12 C10. It states that a parent, guardian, or caretaker commits this crime if they knowingly leave a child under 13 unsupervised by someone at least 14 years old for 24 hours or more. Child abandonment is a Class 4 felony, which can result in imprisonment from 1 to 3 years. A second offense is a Class 3 felony, carrying a sentence of 2 to 5 years. Parents are rarely sent to prison immediately. Courts often grant probation instead, requiring cooperation with the Department of Children and Family Services. If probation is completed successfully, there is no conviction on record. However, this opportunity is available only once. There is also a lesser charge called endangering the life or health of a child, 720 ILCS 5/12 C5. This broad law includes any situation where a parent knowingly puts a child under 18 in danger. Leaving a child unattended in a car is a specific example. If a child under 6 is left in a vehicle for more than 10 minutes without someone 14 or older, it is considered child endangerment. This crime is a Class A misdemeanor, which can result in up to a year in jail. How long can you leave a child alone in Illinois? Legally, a child under 13 should never be left alone for 24 hours or more. If a babysitter is involved, they must be at least 14 years old. While shorter durations are not explicitly illegal, prosecutors consider several factors when determining if a child was left in an unsafe situation. These factors include the child's age and maturity level, the number of children left unsupervised, whether the child has special needs or medical requirements, how long the child was left alone, the time of day and location, whether the child had access to food, shelter, and communication, the reason the parent left the child alone. Parents facing child abandonment charges often use these factors to defend themselves, arguing that they took reasonable precautions. However, the safest approach is to avoid leaving young children alone altogether. Divorced or separated parents and child supervision. Illinois law sets clear rules about child supervision, but divorced or separated parents may have additional guidelines in their parenting agreement. Typically, an allocation of parental responsibilities and parenting time agreement outlines how long a child can be left alone. Many parenting agreements include a right of first refusal clause. This means that if a parent needs to leave the child for a specific period, often 8 hours or more, they must offer the other parent the opportunity to take care of the child before arranging alternative supervision. In the modern age, technology like cameras, cell phones, and smartwatches allows parents to monitor their children remotely. If necessary, parents can modify their parenting agreements to reflect these advancements. However, only one parent needs to enforce the law or a parenting agreement, so disagreements about child supervision can lead to legal disputes. If you're dealing with these challenges and need guidance on Illinois child custody laws, contact the law office of Russell D. Knight at 773-334-6311 or visit 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.